SJC-08047, Commonwealth versus Kolenovic.
May it please the court, my name is Michael Schneider and I represent the defendant appellant in this case, Inez Kolenovic. If I may, I would like to begin by addressing the first issue, which is the fact that the trial counsel committed ineffective assistance of counsel by completely failing to address the extreme atrocity or cruelty issue. During his closing argument, he went so far as to say that the extreme atrocity and cruelty theory was a fallback position for the Commonwealth, that essentially the Commonwealth wasn't arguing it, and truly this is the Commonwealth's real position is this is only a case of extreme atrocity or cruelty. The fact is, by that point, he knew that the Commonwealth was pressing its case on both a deliberate premeditation theory and an extreme atrocity or cruelty theory. The Commonwealth argued it, touched upon it during the opening statements. The judge gave preliminary instructions on it. The Commonwealth went through extensive cross-examination of the medical examiner and also of the percipient witnesses with respect to the Cunin factors. The issue was extensively argued with respect to the required finding issue, and defense counsel knew that the judge would be giving an instruction on extreme atrocity or cruelty. So for the defense counsel to try to just duck the issue and pretend that it didn't exist was something that I would urge, consistent with this court's case of Commonwealth versus Westmoreland.
But he argued extensively about the fact that the defendant was basically afloat in alcohol.
Well, certainly.
And that went to both deliberate premeditation as well as extreme atrocity.
But he never argued that it went to extreme atrocity or cruelty.
But the judge's instructions would have made that
The judge
clear.
gave an instruction, and I want to get into that as well, because I think that was the judge's instructions and her supplemental instructions were problematic. But I think it is critical. What really does stand out is when you look at defense counsel's closing statement and his opening statement, you'll see that he simply does not address the extreme atrocity or cruelty issue, and that's what the jury convicted on. And I think it doesn't require—
I am convicted on deliberate premeditation, too. There was certainly sufficient evidence as to that.
Well, certainly, but you know, and there are cases where you might make some sort of a concession if it's going to get you a lesser degree of murder, a lesser verdict. But in this case, he knew that if the defendant was going to be convicted on either extreme atrocity or deliberate premeditation, that he was going to be given a life without parole sentence, and the result would be absolutely the same.
You don't think this is a strategic decision on the part of counsel, and that we should recognize that as such?
I would call it a strategic decision. I don't think the Commonwealth is wrong in characterizing it as such, but I would say that under the circumstances, it's manifestly unreasonable for counsel to have simply focused on deliberate premeditation. The Commonwealth suggests that defense counsel did more, that in some ways by somehow arguing an intoxication defense, that it was somehow going to convey to the jury that it could somehow, I guess, negate extreme atrocity or cruelty. But the problem is the jury had no guidance from either the defense counsel or the judge as to how intoxication could possibly get him there. The Commonwealth suggested that it also might have removed the issue from murder altogether. But again, there is no argument by defense counsel with respect to malice.
Given the nature of the facts here, what would the defense attorney have argued, do you think, as to extreme atrocity or cruelty that could have been effective?
Well, first, the defense could have certainly picked up on the Gould instruction and pointed out to the jury that the ultimate, as this court has held, the ultimate issue in these cases, the ultimate element that needs to be proved is whether the killing was committed with extreme atrocity or cruelty. And you will hear from the judge that a defendant's mental impairment as a result of consumption of alcohol is something that you should consider in making this ultimate determination as the repository of the community's conscience in deciding whether this was a killing, a gruesome killing committed with extreme atrocity or cruelty, or in fact the killing of an extremely highly impaired man who had been an alcoholic since his early teenage years.
Doesn't the number of stab wounds really hinder that argument?
I would submit that that's the other piece of what the defense counsel should have been arguing. In a case where someone is an alcoholic under the impress of this kind of extreme alcohol intoxication, and we're talking...
Was it nine stab wounds?
There were 9 stab wounds. There was one fatal wound.
Right.
But the point.
Then you have the statement to the woman that it's too late.
Well, with respect to the 9 stab wounds, if I may, Your Honor, defense counsel could have and should have argued that both the 9 stab wounds and the evidentiary consideration under Cunin of disproportionate force, those are both the actions of someone who is acting under the impress of a near fatal dose of alcohol. That's what he should have argued. He should have argued the Gould instruction, that you can simply make that overall determination and consider his alcoholism, or with respect to each of the elements. The worst elements, disproportionate force, and the number of stab wounds, the extent of the injuries, were a function of a guy who was simply out of control as a result of this near fatal dose of alcohol.
Counsel, can you address for me or explain, refresh my historical memory on the theory behind extreme atrocity and cruelty murder as opposed to premeditation?
That's the history in this court.
Well,
that's
just
a big question.
what's the theoretical? What are the theoretical underpinnings between those two theories?
Well, as I understand it, certainly cases like Gould and Perry in the early 1980s kind of presented a teaser, certainly for the criminal defense bar, but certainly suggested that if a malicious mind is something that is something that can aggravate something to murder, then an impaired mind is something that should mitigate murder, and that's something that is consistent.
And how does that relate to extreme atrocity and cruelty?
Well, certainly someone, so what the Gould and Perry courts have said is, with respect to both intoxication or drug impairment and also mental impairment by reason of a mental disease or defect, is those are things which the jury should consider with respect to whether a killing was committed with extreme atrocity or cruelty. And the model instructions adopted in 1999 and that the courts have followed since certainly do require a judge to give an instruction, with respect to that. With respect to, but the court has also handed down the Cunin case and has rehearsed a whole series of iterations about exactly how the Cunin instruction itself should be given. But the court has ultimately determined that these are evidentiary considerations. They're not sentence enhancers. They're not aggravators. It doesn't run afoul of Apprendi not to give a unanimity instruction. These aren't elements. The ultimate element for extreme atrocity or cruelty is simply whether or not the killing was committed with extreme atrocity or cruelty, and a defendant's mental state, including alcohol consumption and intoxication and a history of alcoholism, are things that the jury should consider. So as I understand it, even if a jury finds that there is a single 1, 2, 3, 4 Cunin factors, the jury is the repository of the community's conscience. And consistent with Paulding, I don't think this runs afoul of this court's jurisprudence with respect to the jury determining the degree of murder. But the jury can determine that this was not the act, a gruesome, horrific, horrible act of a mean drunk. These were the actions of someone acting under the impress of alcohol, and a jury can determine, as I understand it, under the part of Gould and Perry that survive, that a killing was nonetheless committed with extreme atrocity or cruelty. And I don't think, because of trial counsel's failure to address the issue, he completely ducked it.
So what
that the
specifically
jury had
would
any
you
idea.
suggest? What specifically should he have done? What should he have argued? What should, specifically?
I think he should have argued, number one, he should have spent some time explaining how Dr. Fox's testimony pointed out that the defendant was hardly knew what he was doing. He was completely out of control. We're talking 0.25 to 0.30. So he should have, number one, set that issue up. And then he should have pointed out that that level of intoxication is something that the jury should consider, as the judge will tell you, should consider when you decide whether this was a killing committed with extreme atrocity or cruelty. I don't think the jury fully understood that. And then secondly, he should have argued that with respect to each of the Cunin factors, or all of the Cunin factors considered together, the jury could certainly understand that each of these things that seemed so horrible, so cruel, and so atrocious were in fact the acts of a deranged person acting under the impress of alcohol.
So your
and he didn't do that.
Your point then, as I understand it, is that when we look at this, we're really looking at it entirely from the perspective of the defendant and not what the victim went through.
Well, the first Cunin factor, indifference or pleasure, is the one thing that brings into play directly the defendant's mental state. The other 6 Cunin factors don't explicitly do that, but to the extent that this court has sanctioned this part of the Perry-Gould instruction, I would submit that the jury needs to understand that it can consider a defendant's mental impairment with respect to each of the Cunin factors and with respect to the ultimate element of extreme atrocity or cruelty as a whole. And I think that's essentially what this court was driving at in the Howard decision. I think I mistakenly listed it as being a 2017 when it was a 2014 decision, but also the Rutkowski case. And I think that's what the jury didn't get. And I think the same is true, and it's clear when you look at the judge's instructions. So she gave the correct instruction that was consistent with the model instruction. I'm not disagreeing. I think she said specifically, or something to the effect of, in considering the 7 Cunin factors, you should consider the defendant's consumption of alcohol in determining whether the killing was committed with extreme atrocity or cruelty. That's the Gould-Perry instruction, and I think the judge was correct to give it. But under the facts of this case, she did not make it clear, and I think it shows that there is a problem, because I think ultimately the Cunin instruction on extreme atrocity coupled with the Gould instruction is just inherently confusing. And it simply doesn't make clear to jurors that they can consider mental impairment with respect to each of the 7 factors, nor does it make clear that exactly how the jury can consider mental impairment with respect to the ultimate element, whether the killing was committed with extreme atrocity or cruelty.
How does the defendant's intoxication have any bearing on the victim's receipt of pain?
On the victim's suffering?
Yeah.
Well,
Victim in any less pain if the defendant's drunk or sober?
so what I would submit is, first of all, it's not entirely clear. It seems to me that from the Gould-Perry part of the instruction, which is the very first part of the instruction, and it's insinuated into the rest of it as well, it's not clear if the jury finds that there, and each of them can find...
I get it that some of the Cunin factors have some mental awareness by the defendant, but I think it's 3 of them. The rest don't.
But with respect to the issue of if the ultimate element is extreme atrocity or cruelty, and if the jury is also told that they should or must or may consider the defendant's consumption of alcohol with respect to whether or not the killing was committed with extreme atrocity or cruelty, I don't believe the jury is disregarding the instruction for those juries that decide that no, this was the action of a deranged, impaired individual and not a killing committed with extreme atrocity or cruelty. And the problem is, I think that it does run, as you suggest, Justice Gaziano, it does run contrary to the line of this court's cases that basically says it's sufficient as long as there's at least sufficient element with respect to one of these evidentiary
we have
considerations.
overkill, we have number of blows, we have pain receipt by the victim, all of which have nothing to do with the defendant's mental state.
Except that the defendant's mental state under the Gould-Perry part of the instruction, as I understand it, can completely outweigh
Well,
the
I guess that's what
existence of any
I'm
one
trying to
Cunin factor.
understand, just theoretically.
Yes.
Because I always do a little bit better with this when I understand the theoretical underpinnings of
Okay.
something. And My understanding of deliberate premeditations, we're focused on intent, the intent of the defendant. And with extreme atrocity and cruelty, although some exceptions have been carved out, we're primarily focused on the acts, not necessarily the intent. Although maybe a jury can consider it based on Gould and Perry and some of the other Cunin factors. But so what's the real difference then? If you started taking this approach, what's the difference between deliberate premeditation and extreme atrocity and cruelty?
There's still a huge difference because there's different malice that applies to each of them.
But aren't you at that point going back into malice through extreme atrocity and cruelty by getting at defendant's state of mind?
No, I don't think so. The ultimate element that this court has always said is, jury, was this killing committed with extreme atrocity or cruelty? In some ways, even though they are given a number of evidentiary considerations, and even if they're told that one of these is enough, ultimately their determination as the repository of the community's consciousness.
If someone is drunk out of their mind, and as you argue, and there's evidence from Mr. Kolenovic, and they light a car on fire and a victim's inside the car and horribly dies in a fiery death, is that sufficient?
If you're asking me under Lattimore whether it's sufficient, I would have to say that the answer is yes. The court has repeatedly held that just one of the Cunin factors is enough, even though the court has always been disclaiming that it's an element or an evidentiary, a sentencing aggravator. It's just simply a consideration. But it seems to me that a jury could very well determine this person was so out of his mind, especially now that we've learned that this person was an alcoholic, didn't understand his alcoholism, didn't understanding that starting to drink and then having another drink could put him completely out of his mind. The jury could determine that even in that gruesome circumstance. And one of the problems I think with extreme atrocity or cruelty, I think one of the things that can be very frustrating about it is it's ultimately, notwithstanding all of the evidentiary considerations, it's ultimately a very, very subjective decision on the part of the jurors. Are we just really disgusted by what has occurred here? That's ultimately what it is. And the question is, when you leave disgust make disgust the centerpiece of an element of a crime without providing more guidance. And
So I guess I'm having some trouble understanding whether or not where you're going means that we have to go to basically the position of the concurrence in Riley and in, I forget the name of the other
Berry.
case.
Berry.
Berry,
Berry,
right, not
Commonwealth
Perry,
versus
Berry,
Berry.
yes. Or whether you're saying under our current case law, we're already there.
Well, I'm saying two things. Under our current case law, I think we are almost at the point where it should be clear that jurors need to be told that the jurors need some clarity as to whether a defendant's mental impairment can completely negate one or all of the Cunin factors, or whether the defendant's mental impairment can negate extreme atrocity or cruelty. The Gold-Perry part of the instruction seems to suggest it does. In addition to that, as I would argue, and as I do in my brief, that this court should consider doing what some other states have done and what Justice Gantz and Justice Duffley had suggested in Commonwealth versus Berry and Commonwealth versus Riley, is that the court take another real look at the question as to whether or not there should be a mens rea element, a requirement that some states have, that there be some sort of an intent to cause suffering, an intent to commit a truly atrocious and cruel act or a depraved act.
Okay, what I'm trying to get at too is, are you suggesting that the judge in any way gave an incorrect instruction here when she gave her supplemental instruction? The jury asked the question, is the defendant's intent or his purpose/objective a consideration we should use to evaluate each of the 7 factors of extreme atrocity? The judge responded that, quote, certain of the Cunin factors do in fact take into account the defendant's frame of mind, his state of mind, but others did not. Are you saying that that was incorrect?
I'm suggesting that it provides insufficient guidance, that it was number one, that it provided insufficient guidance under the circumstances of this case to the jury, because when the jury was asking about defendant's state of mind, What they were interested in was his mental impairment. That's clear. I mean, that was the central issue in the case.
Because of his extreme alcoholism and intoxication.
Because of his extreme alcoholism and intoxication. And,
So the question there, though, is, are you saying that the judge was saying only that the import of what the judge was saying was that, you only take this into account with respect to certain of the Cunene factors if you find them, or that it was precluding the jury from considering the mental impairment as to each of the factors, or to the ultimate question of whether or not it was extreme?
I think it would have left. I think this supplemental instruction would have left the jury confused about to what extent they could consider Mr. Kolonovic's alcoholism.
So do you think the instruction should be that the Commonwealth has to prove that he had an intent to cause serious bodily harm?
Well, that would be second-degree malice, and that's something.
I guess that's my point.
Well, I think that there's an argument, and it really goes back to the court's sort of broader philosophical jurisprudential point that was made in Gould, which is that if a malicious mind aggravates, an impaired mind mitigates, and that's something that reaches way back into Anglo-American common law and judicial and moral philosophy. And I think that the issue is, should we be meting out the state's highest, most severe punishment? It is a capital case in Massachusetts. Someday, God forbid, the death penalty could be back. But for now it isn't, but it is still life without parole. People are buried behind walls for the rest of their lives. And I'm suggesting that under those circumstances, we shouldn't leave a jury guided only by whether or not they are so disgusted with a crime about how atrocious and cruel it was in aggravating it to first-degree murder, and that the Cunene factors as they exist don't do enough, and that there really is a contradiction within this court's jurisprudence. If you say that one factor is enough, but you also say that mental impairment can be considered in determining the ultimate question of whether the act was committed with extreme atrocity or cruelty, I don't see how that's not a contradiction. And even if it's not a formal logical contradiction, I don't see how a jury could not be confused.
Did counsel object to the extreme atrocity instruction?
No.
And did counsel object to the supplemental instruction?
No. I know I'm out of time, but I would ask that the court just take a very close look in considering a 33E reduction, or alternatively the whole question of remand at the post-conviction evidence. I would really suggest Pagan postdates the Rivas case. Pagan did recognize that there was appropriate use of a psychiatric report that was only admitted in the as part of the post-conviction evidence.
So if we assume that the judge below should not take that into account, are we permitted to take that into account in doing 33E?
Well, I certainly think you are, to the extent that there are quite a number of cases. Well, the language of 33E itself focuses this court on looking at the whole case.
Yes, the
and
whole
also
case,
the
but
whole
here, you're saying, so the whole case includes the allowance of the motion for new trial on the basis of the dual diagnosis, which was then reversed, and the information that was available to the court at that point?
It includes all of the evidence that emerged, regardless of whether it was reversed or upheld. This court should have the right to take into consideration the material that went to the defendant's character. That's the Jefferson case, that went directly to the defendant's character, his history, his mental impairment, his severe PTSD, his history of childhood abuse that triggered this, beatings with belts and rods and 2x4s and tools and whatever was at hand, and his severe PTSD, which this court in Kolenovic 1 in the first iteration of this didn't question, which the trial court fully credited. Remember that evidence that I'm asking you to take into account is objective evidence based on imaging, psychometric testing, extensive interviews. I think the court, when you look at the trial court's review of that information, it was clear that she felt that was extremely credible and would have formed the basis for a very strong insanity defense had counsel chosen to to go that route. And this course of court decided that it wasn't inappropriate for a very seasoned lawyer to make an intelligent decision not to try that. But I think this court has the right and power, and I think that a case like Brescia is a good example. The footnote 11, I think it'll become as famous as the Caroline Products footnote 4, but the footnote 11 in Brescia makes clear that this court under 33E has the right, the duty, the right, the obligation, the authority to look at the entire record in order that the ultimate verdict be consonant with justice. And I would strongly urge the court to do that.
All right, thank you.
Thanks.
Mr.
May it
Townsend,
please the
good morning.
court, Thomas Townsend for the Commonwealth. Unless otherwise directed by the court, I'll deal with the issues in the reverse order as my brother, beginning with the 33E 25B2 issue. I think this court has already squarely addressed this issue in Rivas. In Rivas, there was a motion for a new trial in which the defendant testified to his alcohol dependency and drug use on the night of the murder. None of that was admitted at trial. At trial, there was evidence that he had consumed some beer, but nothing regarding drug use. The trial judge on the 25B2 motion found that that was inappropriate to consider. This court, in affirming the trial judge, said that was inappropriate to consider in a 25B2 motion. In Rivas as well, this court noted that a trial judge considers essentially the same considerations in dealing with 25B2 as this court does in 33E. And so by extension, if it is improper for a trial judge to consider post-trial evidence that is developed, it's likewise improper for this court to consider it in 33E context.
With regard to that statement which you're referring to, was that done in the context of considering whether we may consider post-trial information as part of our 33E analysis, or was that just said generally?
It was dealt square on. Both sides briefed it. The defendant invited this court to consider his testimony from the post-trial hearing in reducing his verdict, and this court found that that would be inappropriate, that this court is bound by what occurs at trial, which makes sense. In the 25B2 context, the judge is looking to whether the evidence, though sufficient to support the verdict, points more strongly to a lesser offense, whether, in other words, the weight of it was against the weight of the evidence. So the court is looking at the evidence. It's wholly improper for the defendant to try a case on an alcohol intoxication defense, lose there, find experts years later to diagnose him with PTSD, raise that in the context of a different claim. It was an ineffective assistance of counsel claim. And then after the fact, when that ultimately does not pay off, go back to the trial judge and say, we now ask you to consider that evidence, which the jury did not hear, that trial counsel specifically did not want the jury to hear.
Now, I understand why that's not fair as to the, maybe as to the rule with respect to the trial court judge. But I'm not so sure why it's clear as to 33E. If you even look at the language of the statute itself, it seems to give us a fairly broad palette on which to paint,
Well, I think,
or with which to paint.
well, this court has interpreted it as pretty much coextensive with the trial judge's power under 25B2, which would be cabined to the trial evidence.
But we don't have to do that, do we?
Well, there have been considerations where this court has, say in Jefferson, looked at criminal history. But it was not the primary factor. It's still within the, while viewing the evidence. In Jefferson, the court said the heft or the thrust of the evidence. Even though it looked at the defendant's criminal history, you're still within the context of the evidence. What the defendant is proposing is quite extraordinary, taking wholly different topic, placing it on top of what was presented at trial, and asking the court to reduce the verdict on that. That's what the trial is for. That's what the jury is for. Pagan, the motion judge, dealt with Pagan to a great extent, and it's in my addendum, and she distinguished that. And Pagan, on the 25B2 judge, considered a technically it was a post-trial report from a expert, but that expert had testified at trial. The defense was still the same. So the judge referenced that report. Technically, it was outside the record, whether it was appropriate or not. it's hard to say, but it's not a wholly separate consideration.
Yeah, the thing is, though, we're talking about mental impairment either by virtue of intoxication or I just took some, let me see, at the post-trial hearing, it looked like there was not only alcohol dependency, but PTSD, brain injury, intermittent explosive disorder, dysthemic disorder, social phobia, general anxiety disorder, and several unspecified personality disorders, all of which would have gone, I understand, to the possibility of a defensive lack of criminal responsibility as opposed to the intoxication defense as to the specific intent as at trial. But if we're looking at this in terms of a 2033E review, why can't we take into account sort of the extent of the mental impairment may have been greater than merely alcohol dependency?
Well, two answers. One is the trial was based on alcohol dependency.
Understand that,
It
yeah.
did not go in front of, but also there's a fairness aspect. That evidence was developed in a post-trial hearing dealing with defense counsel's strategic decision not to present that evidence. The Commonwealth retained an expert who viewed the same data, Dr. David Johnson from Yale New Haven, director of the Post-Traumatic Stress Disorder Center, and he came to an opposite conclusion, that he did not have PTSD. But the Commonwealth did not push the angle regarding the other experts because if the court remembers in Kolenovic 1, Dr. Johnson was specifically referred to defense counsel by Dr. Fox, who was the retained expert. From the Commonwealth's perspective, all that mattered is what would Dr. Johnson have said if contacted in 1999 about the defendant's PTSD. We did not have the incentive to scrutinize thoroughly the considerations or the conclusions of the other experts because we're concerned with what Dr. Johnson had said. Like in Revis, where you take one issue that was litigated post-trial and then try to meld it onto 25B2 or 33E, it's not a good fit. It's not the reason that this was litigated.
Same incentive as you would have in front of a jury to litigate the defendant's mental state.
That is correct.
Post-trial.
That is correct, because our strategy was, number one, there was no deficient performance because it was within the trial counsel's discretion. But number two, under the second promise of Farian, there was no prejudice because if he had contacted Dr. Johnson, he would have said no.
And we never got to that in our,
You necessarily did not get to it because you've indicated the Commonwealth's first position.
right.
And I think that's important. I do want to address the other
Right,
issues.
I'm just trying to, I know that Diachenko is a cruel and unusual issue, but it ultimately is a court saying, golly, we know a lot more about children's brains than we did before, and taking an action which is the equivalent of a 33E reduction to second degree. So I know it was not a 33E decision, but how does that square with your argument that we can't?
Well, I think there are a couple of things. Number one, that's flying with juveniles. And also, this court looked, in the Supreme Court, and Miller looked to the consensus of the scientific community in determining that. Here we have a thin slice. The defendant was able to find 3 doctors years after trial to say this. We went to the original doctor who was recommended. He said something else. So it's not clear. But also, I think we have to step back and say, well, this is what the trial is for. If this is something that would have negated malice, if this is something that was truly potent, that's why we have a jury. And the defense counsel here, according to this court, reasonably concluded that alcohol defense was a better strategic decision than going with a dual diagnosis, alcohol and PTSD defense. And this court went into it in great depth. And also, this court, in that case, very well explained why trial counsel is vested with much discretion in determining how to defend a case. Whether in Kolenovic 1, it's which defense to pursue, or in Kolenovic 2, what to say in a closing argument. Of all the aspects of trial, I submit that a closing argument should be afforded the most discretion. Because counsel, aside from all lawyers are different and have different tactics, counsel was in the trial for 10 days. He saw the evidence develop. He viewed the jurors. He could tell what perhaps worked, what perhaps didn't. And when counsel here, he had 40 minutes to deliver his closing argument. He combated what I suggest was the lead theory of deliberate premeditation. And he championed the alcohol intoxication defense, which, if accepted, would have knocked out malice on the deliberate premeditation theory as well as the extreme atrocity.
But, you
Theory.
know, you've been hearing about the supplemental instruction that was ultimately given, and just the sort of the tension between Gould and Cunneen. That's, I think, apparent even in Justice Abrams's concurrence in Cunneen. And the sort of what do you do with this whole notion of there is impairment, and what factors does it go to, and the absence of any sort of attempt to use the alcoholism that he did argue as a way of showing, well, you know, it goes to these things too. And that's really missing from the closing, right?
It was broader than I suggest. He argued Dr. Fox's testimony that the alcohol impaired the higher brain functions. Dr. Fox testified anyone over 0.20 is incapable of intending anything. Now, whether that's true or not
Well,
is,
okay.
you know, beside the point. That was in front of the jury. There was evidence he had over 0.20. Ergo, he's incapable of intending anything.
Got him
Defense
pretty
counsel
far
drew-
on deliberate premeditation, but what about the factors about like the slicing of the neck and all the rest of that, which was, does the jury get to take that into account as to those factors?
Not specifically in the closing. And I think defense counsel had a couple choices. You can fight the battle on the prosecution's terrain, where you can talk about deliberate premeditation, extreme atrocity, or cruelty, or you could fight it on your own terrain, where you talk about alcohol intoxication. I think that's a manifestly reasonable defense. Why specifically combat that when you can highlight your own case? And there's precedent from this court, the United States Supreme Court, which says champion a defense, not specifically rebutting prosecution theory, is manifestly reasonable. It's a strategic decision. The last witness they heard was Dr. Fox. Counsel argues Dr. Fox. Rather than ceding that territory and going back to what the prosecution was arguing, continue with that. I think that's manifestly reasonable. Sure, 20/20 hindsight, we can look back at it and say, oh, well, if they convicted of extreme atrocity, should have done something else. But we look at that when we deal with questions of whether it's manifestly unreasonable. There's two considerations. There's the temporal and substantive. Temporal, you don't use 20/20 hindsight. Substantive, you look at what would ordinarily trained lawyers have thought. Would they have viewed that as incompetent? I suggest doing that was not objectively incompetent. I do want to touch on the...
There, before you leave this, I mean, it seems as if part of your argument, not precisely what you've said, but is that it was a perfectly sensible strategy for defense counsel to not attempt to address specifically extreme atrocity or cruelty, but that's in part because our guidance that we ultimately give is so screwy that the more you focus on it, the more you get into how difficult it is for state of mind to affect extreme atrocity or cruelty, where some of the Cunneen factors have nothing to do with state of mind. So is part of the problem that we have an inherent disconnect in our extreme atrocity or cruelty instruction and on the Cunneen factors and Gould? I mean, is there something that doesn't fit?
Well, I recognize that there is a tension in the case law. I don't think that spilled over into the trial here. I think dealing with the objectively extremely atrocious way.
Right, there's no question that if you look to see what happened, it was atrocious. I
Right.
get that. And I understand why you may not want to focus on that issue, but yet we tell the jury, both in our model instructions, which are based on the Gould and its successors, that yes, you, the jury, can find that there was not extreme atrocity or cruelty based on intoxication.
Correct.
We don't tell them how they are to do
Right.
that, but we give them that prerogative. And is there a certain, I mean, is that fair to a jury to be saying, yes, you may do it, but then we're going to give you further instructions which effectively say that some of these things are what they are, have nothing to do with intoxication.
I understand the concern. I think part of the problem is Gould and Perry predated Canine. And I understand Your Honor's concern in your Berry concurrence. I think at some point that will need to be addressed in a case where that's preserved. Here, the judge followed defense counsel's suggestion. Defense counsel filed a motion asking for that instruction to consider. Trial judge gave that. She went one better. Instead of may consider, she inserted should. You should consider. That goes beyond the models. The 1999 model goes past the 2013 models. When the jury came back with that question, the word of the question is important. They said, is the defendant's intent or his purpose/objective? Prosecutors suggested saying no, and the judge could have done that because that technically, legally would have been a correct answer because there's no mens rea with respect to the third aspect. But defense counsel said, well, I think the jury wants something. At least for the first Canine factor, there is some sort of mental element. And the trial judge said, I think you're right. And due to the defense counsel's urging, she gave an instruction saying you can consider frame of mind. That's not what they asked about. They asked about intent. But she said you can
And
consider
state of mind. Frame of mind, state of mind.
frame of mind, state of mind.
Yeah.
She said both together. And the defense counsel did not object. So I don't know what more the judge was supposed to do in 1999. Going forward, I think if this can be
Today, I mean, our law hasn't
or
changed.
today, at least the issue's been flagged by this court in concurring opinions. So, there will be some case which isn't clearly atrocious killing. It's more on the borderline, where this issue is preserved, and where this court can ask for amici briefing on the issue, because that is, I think, attention in the case law. It does not affect the disposition of this case.
Because?
Because this is unpreserved,
Okay, but other than that, for 33E purposes?
because this is plainly an extremely atrocious killing. It's not more near the line where a future case could be.
But if he's so deranged that he can't appreciate that this is atrocious.
Well, I would also suggest, I would also expect that the future briefing would request that it be a prospective change in the jury instructions, because everyone was doing everything right here. The draft of the 1999 instructions had been published in Lawyers Weekly. Defense counsel recommended that the judge follow that draft. He went further. He submitted a filing recommending to use the consider language for extreme atrocity or cruelty dealing with intoxication. The judge instructed the jury consistent with what the ultimate August 1999 instructions would be, and the 2013 instructions. She did everything right. Defense counsel did everything right with respect to this issue. There's just plainly no error on this issue in this case. Unless the court has any further questions, I believe I reached all my points.
All right, thank you.
Thank you.
And we'll take our morning break.